My fellow colleagues have come up with some very interesting discussion points about the ethical issues and the rights and duties of the stakeholders, but it is also very important to remember that there are laws and regulations from federal and state that should be looked at in regards to what is required for an organisation such as this. Australia has the Privacy Act of 1988, which was amended twice. There was an Enhancing Privacy Protection Act in 2012, and it was amended again in 2014 with the Australian Privacy Principles and Information Privacy Principles. This is what applies to organisations, the Australian government and any agencies. Therefore, this agency would be covered by this Privacy Act. This Act would cover consideration of personal information privacy, collection of personal information, dealing with personal information, the integrity of personal information, and access to and correction of personal information. But there is not only federal law that may cover you. Depending on which state, there is a multitude of state laws which need to be followed. New South Wales laws come under the Privacy and Information Act 2014. Queensland has the Domestic and Family Violence Protection Act 2012. There is no specific act in South Australia, but they do cover it under their Criminal Law Consolidation Act 1935. Tasmania has the Personal Information Protection Act 2004. Victoria has the Family Violence Protection Act 2008. And finally, Western Australia covers it under their Restraining Orders Act of 1997. Both the Australian Capital Territory and Northern Territory are covered under the Commonwealth Constitution and the Federal Acts. In conclusion, it is very important to understand the laws that you need to follow. However, always remember,
Ere ye shall lose an eye for such a trifle, for doing deeds of nature unashamed. The law is such an ass.